Hey guys, thanks for watching the first video in this training series. If you haven't watched the first video, I definitely recommend checking it out. This training is all about the 4 must-have foundational legal protections for your e-commerce business. Avoid being included in the 53% of small businesses involved in a lawsuit. Let's get into this training, which is all about the 4 must-have foundational legal protections for your e-commerce business. Number 1, establishing a legal entity. Number 2, establishing a legal brand. Number 3, establishing written agreements. And number 4, establishing product compliance. Why are these must-haves in your business? A lot of people ask me that. If you take a look at this slide, it shows the life cycle of a typical e-commerce business, from idea to startup to growth to maturity. The 4 foundational legal protections I'll discuss will be key at each stage of your business. There will be many other legal matters you need to take care of, but these 4 will be consistent. The first is entity choice. Choosing the right entity to run your e-commerce business is the foundation. Without this, you open up yourself to personal liability, you risk losing your house, you risk losing money in your bank account, you risk losing your car, you risk losing all of your personal assets. It is by far the most important step in your e-com journey. So what are we going to learn? We're going to learn why you need a legal entity for your e-commerce business. We're going to know how to choose the correct entity for your business and when and where to set up your entity. So let's talk about the why. Why you need a legal entity for your e-com business. When we're dealing with entities, the most often question or pushback I get nearly every time with my clients about the why they need an entity is, well, what if I don't have the funds to form an entity yet? Can I just start as an individual or sole proprietor and switch later? My answer is always no. I do not recommend it, and I'll explain why shortly. I get it though, funds are limited in the beginning, but remember, you are never too small. Just ask Judy from the first video. Also, it's not that easy to switch your business from a sole proprietor to a proper legal entity. If you start off as a sole proprietor, you individually will own all of the business assets. Websites and emails will be in your name. The business licenses will be in your name. You can't just transfer it to an LLC or a corporation without potential tax consequences, administrative headaches, and other issues. So I highly recommend starting with an entity. Okay, so let's get after the why. The number one reason you need an entity by far is liability protection. It protects your personal assets. It protects your personal assets from creditors, from any vendors or suppliers that may sue you, from any customers that may get injured with your products that may sue you, and from competitors that may sue you as well. I'm sure most of you have heard the term liability protection, but I want to make sure you know exactly what that means and how it plays out. So let me walk you through what will happen if you are sued for breach of contract, product injuries, IP infringement, or any other reason. The other party will file a lawsuit in court. If they win, they're going to get a judgment against you, which is just an amount of money that you are required to pay to them. So say the judgment is for $1 million. It could be more, it could be less, but just say the judgment is $1 million. If you didn't have a proper entity set up for your business, that judgment would be against you personally. If you can't pay the total judgment back, which most of us would not be able to, the other party can collect in other ways, like putting a lien on your house, cars, bank accounts, and collecting a percentage of any wages you might have until it's paid off. You run the risk of having to file for bankruptcy. Now take the other side. If you did have a proper legal entity set up, the judgment will be against your entity and not you as an individual. The other party could only collect what the entity actually owns and has, such as the inventory and business bank account funds. They can't touch your personal assets. Other benefits include financial benefits. There are tax reductions and expense write-offs, as well as leverage you can receive in negotiating an agreement or deal with a legal entity versus yourself individually. This is the perception that you are a real business and it isn't just a hobby, where customers and suppliers could really try to take advantage of you. It also makes you look like a real business, right? So being able to tell your families that you are the CEO and owner of a legal entity, right? Which, if you ask me, is pretty amazing. We talked about the why entities are so important for your business. Now let's talk about how to choose the right one. We mentioned earlier the sole proprietor. If you're a single owner and you don't do anything, this is the default. You're just a sole proprietor. You have no liability protection. There are also no formalities to file. You don't have to file any documents except, of course, your seller permit and possibly your EIN for some platforms. All of the taxes just flow directly to you for your personal income tax purposes. If you have multiple owners, the next entity to consider is a partnership. This is the default entity if you have more than one owner and, again, don't do anything. Similar to the sole proprietor, a partnership offers no liability protection. So, if one partner does something on behalf of the partnership and is sued by a creditor or a vendor, customer, or anyone else, they could come after you personally as well as your partner. Again, just like the sole proprietorship, in most states there aren't any formalities. There aren't any state filings except for the seller permit. However, if you do choose this route, a well-drafted partnership agreement is recommended. And again, for tax purposes, the income taxes will flow right through to your personal return. The next entity to consider, and the one I would normally recommend for an e-commerce seller, is a limited liability company or an LLC. Most of you have probably heard of this. Your LLC, if set up and operated properly, is a separate person in the law's eyes. It offers you liability protection. You do have some state filings with an LLC. You need to file what's called the Articles of Organization, or some states will call it the Certificate of Organization or Certificate of Formation. You file this with your Secretary of State. You also obtain an EIN number, which is your federal tax ID number through the IRS. You'll need a seller permit, also known as a sales tax ID, state business registration, and a well-drafted operating agreement. Then each year there's an annual filing to keep the LLC up to date with your state. It does offer the most flexibility when structuring how you want your business to run, especially if there's more than one owner. For taxes, there are various ways you can be taxed. If you're a single member LLC, taxes just flow to you personally through your personal income tax return. This is called disregarded. You could also be taxed as an S Corp, a C Corp, or even a partnership if there's more than one owner. Those topics are a little too complex for this training, but I did want to mention it here. The last entity to consider is a corporation, and there are two types based on how they're taxed. There's a C Corp, which offers you liability protection just like an LLC. It does have double taxation. And I'm not going to get into the weeds with this, but basically, if your entity is a C Corp and your corporation has profits at the end of the year, the corporation is taxed on the profits. And then any shareholder that receives dividends pays individual taxes on those amounts. So that's why it's called double taxation. There are a lot of formalities. You need to file the articles of incorporation. You have annual meetings and minutes, and you have to put together the minutes for those meetings. There's a lot of paperwork really involved. You also have bylaws and shareholder agreements that govern the operations of the shareholders. The S Corp offers the same liability protection and requires the same formalities as a C Corp, but the difference is that unlike a C Corp, there isn't double taxation for an S Corp. Just like the LLC, taxes flow through to you personally. There's a ton of advantages of being an S Corp, and in fact, an LLC can as well, but that is beyond the scope of this training. Here's a chart breaking down the differences between each entity. It might be a little hard to read this, so I'll send you a copy. Just shoot me an email. Okay, we now know the why and how to choose. The next question is, when should you set up your entity? What's the old adage? It's something like, if you want a beautiful large oak tree you're proud of, when is the best time to plant it? 25 years ago, and the second best time is now. So the very first thing you should do, deciding to start your e-commerce business, is set up your LLC immediately. It's the foundation of your business. Remember, without it, from day one, you can be personally liable. You never want to enter into any agreement before setting it up. You don't want to pay anyone money before setting it up. Remember Judy from the last video. The last item to consider is the place to file and set up your entity. A lot of my clients will come to me and ask, well, why don't I file in Wyoming or Delaware? Aren't they business friendly? Yes, they are. But my response is always, always, always your home state. Except in a few circumstances. Well, I won't necessarily get into those, but the reason is that you're always going to have to pay your state taxes in your home state. If your state charges for income taxes, most states also require you to file your entity in the state where you're doing business, which is normally your home state. So if you're running your business out of your house or an office in your state, shipping, packaging, paying contractors and employees, you're considered to be doing business there. So that's a short lesson on the why, the how, the when, and where legal entities. Next, let's talk about branding and making sure your brand is legal. Your brand is the most valuable asset and investment in your business that you can have, as quoted by Steve Forbes right here in the slide. If you spend thousands of dollars and months building a brand, marketing, building a website, only to find out that you don't have the rights to use that name and you have to start over, that would be horrendous. What would you do? Would you even start over, or you just walk away? Don't let this happen to you. If you take the right steps, choose a strong brand name, and make sure you have the right to that brand name as well, you can ensure that the most valuable asset you have is protected. So given all this, what are we going to learn? I'll show you first who needs to worry about trademarks. Second, what a trademark actually is and how it's defined. And third, how you choose the right brand name. Who needs to worry about trademarks? I mean, there's really one simple answer. Anybody that has a business, especially an e-com business, everyone needs to worry about trademarks. Remember Mike, Judy, Crate and Barrel, and K Jewelers from the previous lesson? It is never too early to worry about trademarks. Online spending is set to hit $1 trillion this year just in the US alone, which means more and more e-commerce sellers are entering the industry every day. Protect your brand against ever-increasing seller pool, and this is how you do it. Now that you know all the e-commerce sellers need to worry about trademarks, what does the word trademark even mean? The boring definition is it's any word, slogan, symbol, design, or combination of these things that identifies the source of your goods and distinguishes them from the goods and service of another party. Well, what does that really mean? It means it's your brand for your goods and services. Anything that identifies your brand could be the words of your brand, your logo, your colors, smells, sounds, or anything else. So I usually receive 2 questions relating to the meaning of a trademark. First, can I trademark my business name? Yes and no. If your business name is the same name as your brand name, then yes. A lot of my clients confuse their brand name with their business name. They're not necessarily the same. So your LLC name could be Evan Sauer LLC, for example, but your brand name could be Ecom Lawyer, for example. It's whatever your customer used to identify your brand, what you hold yourself out as to the public. The second question I get is, what's the difference between a trademark, a patent, and a copyright? The simple answer is they protect your business and your products in different ways. We already know that a trademark is your brand. A patent protects the utility or the design of the product, and copyright protects the content and the original work of art or expression. You can have a product that has all 3 protections. Let's take example. What about like a Shark vacuum? So there could be a trademark for the name Shark for a particular vacuum. There could be a patent for the invention and design of that particular vacuum. And there could also be a copyright for the content and videos associated with the marketing of that product. So we talked about the why you need to worry about the trademarks and the what. Now let's discuss how you actually go about choosing the right brand name. The first step is to choose a brand name that can actually be protected and prevent others from stealing it. The best way to do this is by choosing a name so arbitrary and unique that it does not have anything to do with your products you sell or intend to. I know this sounds scary. How will your customers find you if your name is so arbitrary? But look at brands like Nike and Adidas and Haagen-Dazs and Amazon and Apple. They have nothing to do with what they sell. 2 reasons to choose a strong arbitrary name. The first is the likelihood of someone else having it is slimmer. And the second is if you will have a better chance of actually being able to trademark your brand name with an arbitrary name. Because the most common reason a trademark is refused or an e-commerce seller is sued for IP infringement is the likelihood of confusion. You cannot have the same or similar brand name to somebody that's selling the same or similar products. So how do we get around this? By choosing a strong mark. You want to choose an arbitrary name because not all names can be protected by a trademark. If you look at this chart, it describes the least likely type names to be trademarked to the greatest chance. So let's start with the least likely. A generic mark is not a trademark at all. Your name is a generic term for a product you are selling. For example, if your brand name was Apple and you were selling the fruit apples, you could not trademark that. It's just a definition of what you're selling. Side note, my wife hates this example because I use it multiple times a day on calls with clients. So you can't have a generic brand name. If you want to have a trademark rights to it, the next level is descriptive. Descriptive names are also poor candidates for trademark protection. It's descriptive if it actually describes what the product is, what it does, who it's for, or any major component of it. For example, if your brand name was a desk drawer and you sold drawers that slid into a desk, this would actually be descriptive and you wouldn't be able to get a trademark for it. Third is suggestive, and these marks are a little stronger. They kind of hint at what the product is without actually showing what it is. Take, for example, the brand name Chicken of the Sea. It suggests an image of the type of product, but it doesn't actually indicate what that product actually is and what is being offered. And then the last is the arbitrary. Arbitrary names offer the greatest chance for trademark protection. If we use Apple as an example again, but this time instead of selling fruit, I sell computers, the name is so arbitrary and unique as to the products I sell, it has nothing to do with the product that I sell. We can get trademarks because it's so unique. Now that you have a strong brand name, The next step is to do a search to make sure that nobody else has the rights to that name. Again, the most common reason a trademark is refused when you go to register it is the likelihood of confusion. What this means is that your name is the same or similar name to someone else selling the same or similar products. The reason for this is protection of the consumer, protecting them from being confused as to what and who they are buying from. In the United States, trademark rights are created through use of the mark in commerce, which means that once you sell a product or service with your mark, you own the trademark rights to that name, assuming somebody else doesn't have to use it or hasn't used it first. That's the purpose of the search, to make sure you are the first to use the mark, or again, similar mark with your products or similar products. So how do you do the search? This can be very complex, but I generally like to break it down into two phases. The first is the preliminary search, or the knockout search as some call it, and if that passes, then the second is the comprehensive search. For the preliminary search, I recommend the following order. Also, the Land My Brand ebook that I created will walk you through each of these steps. So if you don't have it, let me know and I can email it over to you. So the first step in the search, the preliminary search, is go into Google or your preferred search engine and simply type in your exact brand name in quotes and click search. If your name pops up and is associated with the same or similar products, you should choose a different name. You know you can't use it. If it does not, then the second step is taking out of the quotations and search again for any similarities. When comparing your mark to similar marks, think about all the possible variations. Look for misspellings, check for vowel substitutions, check for consonant substitutions, and look for word and number substitutions. Again, look for similar goods. This is one of the requirements for likelihood of confusions. So you're going to narrow your search to the marks for goods and services might be competitive to yours. Ask these questions. When a consumer knows what goods and services you offer, what other goods and services might they reasonably expect you to offer? What goods or services do your competitors provide that you don't? In a department store, what products might be displayed in the same aisle as yours? What other products are commonly used with yours? So here's a summary of how to assess the other marks. If a mark is identical or very similar and goods and services are the same or closely related, then the mark is definitely relevant to yours. If the mark is identical or very similar and the goods and services are somewhat related, then the mark is probably relevant to yours. If the mark is somewhat similar and the goods and services are the same or closely related, then the mark is probably relevant. If the mark is identical or very similar and the goods and services are unrelated, then the mark is possibly relevant to yours. If the mark is somewhat similar and the goods and services are somewhat related, then the mark is possibly relevant to yours. If the mark is somewhat similar and the goods and services are unrelated, then the mark is probably irrelevant to yours. And if the mark is not similar and the goods and services are unrelated, then the mark is irrelevant to yours. So if you don't find any similar hits, you can now move on to searching domain names. You repeat the steps I just went over in analysis performed with Google to do a domain search site like GoDaddy. If that search is clear, next you can perform the same steps through your state Secretary of State website. This will ensure that your mark is not taken at the state level. The final step and the most complex is searching through the United States Patent and Trademark Office, or the USPTO for short, through their online portal. This is the most complex. Here's a screenshot of what the site looks like so you have a better idea. And again, the Land My Brand ebook will walk you through this search in detail. I don't want to bore you with all the details here. Once the knockout search or the preliminary search passes, then the final search phase is the comprehensive search. I usually recommend hiring a tech company to perform this search. They will search all sites, trademarks, social media, business names, and everywhere else online. These are algorithms which takes a fraction of the time it would take us. The company we use sends us a detailed report, which we review and analyze with our clients. Once that comprehensive search passes, it's time to get the trademark registered. So what is the actual trademark process? The trademark process starts with the filing of the trademark application with the USPTO online. The filing fee at the time of this training is $250 per class or per category. Once the application is filed, we monitor it for every 2 months just to see what's going on. The USPTO will take anywhere from 2 to 6 months to review the application. Once reviewed, they'll either send what's called an office action letter detailing out reasons why the application was denied, or a notice of publication moving the application to the next phase. If you receive an office action letter, you must respond within 6 months, or the application will be abandoned. We don't receive many of these because we do such a thorough job while we're doing the searching and analysis in the beginning. We don't want our clients to spend tons of time and money with marketing, packaging, and inventory, only to find out 6 months later they cannot use their brand name or their logo. If you receive the notice of publication, your mark will be published in the USPTO's newspaper for 30 days to give anyone else the opportunity to object to it. This doesn't happen often because honestly, I'm not sure who reads that paper. But if it does, we deal with it. Although there is software out there that now searches these applications and publications so companies can object to the marks. After the publication, you'll receive your trademark registration. Usually takes, roughly 6 weeks after that or so. And then after the registration, you'll be required to continue to use the mark and maintain it and file documents every 5 years. One question I get a lot is, what are the advantages of registering your trademark? If I automatically have trademark rights when I use the mark in commerce, why do I need to register it? Well, there are many advantages. One of the biggest advantages now is that all e-commerce platforms and social media sites have processes where you can submit your registered trademark if you see someone else infringing, and those platforms will take the other listing down. It also creates a legal presumption that you are the owner of the mark. Otherwise, if any issue came up, you'd have to go to court to prove that you were the first one to use the mark, which can be costly. It gives you a legal presumption that you have the exclusive right to use your mark nationwide instead of just, in the states where you sold it, with the goods and the services that are identified in your registration. It puts the public on notice that you're the owner of the mark. If there's a question as to who owns the mark, it can be looked up in the USPTO's online database. What I like to call it prevents the good people from using it. The bad people are just not going to care, but it prevents the good people who are doing the searches. It also allows you to use that, I'm not sure if you've seen it, but the R symbol in a circle, and you can put it next to your brand name, which again, will prevent the good people from stealing it and using it. And then if you're an Amazon seller, you can get brand registry, which is a huge benefit. And then finally, it adds a ton of value to your business. I've seen this in businesses that I've helped my clients sell. Just having these trademarks in place and the brand name and logo and identity increases exponentially their value of their business. So another question I get a lot is, how do you maintain your trademark so you don't lose the rights? Trademarks should be set off from the other text. So your logo, your color, bold, font, capitalization. You want to give notice to the rights using TM, SM for unregistered marks, or that registered symbol with the R in the circle for registered marks. Trademarks should always be used as adjectives and not as nouns or verbs. As an example is using Kleenex tissue, not a Kleenex. You want to avoid what's called genericide, which are trademarks that become generic. Kleenex is an example above, and Velcro is a good example. This is actually a really funny video Velcro put together to try to avoid and help explain becoming generic.
You're a company that's so successful that everywhere you go, you see the scratchy, hairy fastener, and you say,
"Hey, that's Velcro!"
But even though we invented this stuff, our patent lapsed 40 years ago. Now no matter who else makes it,
you still wanna call it Velcro.
You think it's awesome for us, we're famous, but we're lawyers and it's causing us grief. Cause there are trademark laws being broken. It's all here in this short legal brief.
And we know that this is confusing because Velcro brand is who we are.
But if you call it all Velcro,
we're gonna lose our circled arm.
This is called hook and loop. This part's a hook, this part's a loop. You call it Velcro, but we're begging you. This is f***ing hook and loop.
we know this seems ridiculous. This is a first world situation.
And we made $500 million last year.
I went to turn to my last vacation.
And we're asking you not to say her name. We took 60 plus years to build. But if you keep calling these Velcro shoes, our trademark will get killed. Yeah!
We aren't just doing this for us. We're doing it for all the successful brands that got so popular, people started using the brand names the wrong way. So please, remember.
If you need something to clean up your socks, do it with bleach and not with If you have blood from a boo-boo you made, this is a bandage and not a If you're exercising with someone you're dating, it's in life skating and not I know that bleach stuff is more fun to say, but if you keep doing it, our trademarks go away.
This is called hook part's a hook, this part's a loop. You call it Velcro, but we're begging you. This is fucking hook and loop.
So I mean, I love that video, but it's funny, but it's a really good kind of representation of the becoming too generic, and they're trying to fight against that. Moving on, you also need to police your trademarks. You have an affirmative obligation to police and monitor others from using the same or similar marks, which is what Velcro is doing there as well. There are companies you can hire to do this. Failure to enforce may weaken your mark or render it invalid. So monitor your competitors, counterfeiters, and hijackers. So what happens if you find somebody else who's actually infringing on your mark and using it and they shouldn't? How do you fight or do you defend that? You can do it in multiple ways. You can do cease and desist letters. Sometimes they work, sometimes they don't. You can sue in federal court. You can file a petition with the Trademark Trial and Appeal Board. If the other party filed a trademark application, you could try to prevent them from getting it or have the USPTO remove it. You can force the other party to turn over their domain if it's too close to yours. It's called a domain name dispute resolution. And you can contact website hosts requesting a takedown of the listing, which has become very successful for us with our clients. All right, so we discussed 2 of the 4 foundational legal protections you need in place: setting up a legal entity and making sure your brand is legal. Now let's move on to the written agreements. If you have any business relationships, the terms need to be in writing. I don't know why so many e-commerce sellers are paying people money for services without knowing exactly what they're paying for. Don't let this happen to you. Have the terms written down in detail, and this will save you time and money and help you resolve any disputes that you might have arise in the future. So let's talk about number 1, why you need written agreements in your place, and number 2, what types of written agreements you need for your business. Why do you need written agreements at all? Why can't you just have oral agreements? Well, you can have oral agreements in certain cases, but there are many reasons to put them in writing. First, there's the old adage that there are 3 sides to every story. In this case, there is party 1 side, party 2 side, and the side that is actually written down. We are all very forgetful, especially when it does not benefit us. Second, written agreements help with liability protection. They help avoid disputes. If everything or anything arises in the future without that written agreement, the parties will actually need to testify in court, which takes a lot of time and money. Third, having a written agreement starts off the relationship on a positive note and puts both parties on the same page. You know exactly what to expect. It's a good way to weed out potential business relationships as well. If the other party is unwilling to enter into a written agreement, it may raise a big red flag. Fourth, there are also financial benefits. It gives you potential negotiation leverage when you use professional looking agreements. You have your legal entity in place, so always use those written agreements. So what types of agreements should you actually use? Well, anytime you form a relationship and are either performing services for money or paying money for services, you should have a written agreement in place. Some of these relationships include employees, customers, vendors, suppliers, landlords, manufacturers, independent contractors, and influencers. Agreements can be very complex, and clients always ask me what terms should I actually put in there. I try to make it as simple as possible and really break it down into the who, the what, the when, the where, and the how. For the who are the parties and who will do what? Who pays, who performs the services? For the what services will be performed? What money will be paid? What happens if something goes wrong? What are the penalties and damages if something goes wrong? For the when will the services be performed? When will the money be paid? When does notice have to be sent if something goes wrong? When does the agreement actually end? For the where will the services be performed? Where will the money be sent? Where can I sue if something goes wrong? For the how will the services be performed? How can the money be paid? How can you send notice if something goes wrong? And how can you sue? So try to be as detailed as possible with the terms, but also don't be afraid to use language that a 5th grader honestly would understand. A lot of times when we get to legalese, it throws people off and people don't understand what they're actually agreeing to. So write like a 5th grader. This is just a brief snapshot of written agreements, but again, I highly, highly recommend them in all cases. Once your legal entity is formed, you have a strong brand name that you can protect and is not taken by anyone else, and you have your relationship terms in writing, you're ready to bring your products to market. But before you do, there's one step you need to take, which a lot of e-commerce sellers miss. You need to make sure that your products are compliant with a wide range of regulations. If not, you could face serious consequences, including financial penalties, removal of products from the market, and legal action. So ask these questions when determining what product regulations to file. What is it made of? How does it work? And who will use it? An actual good starting place is a neat tool called the Regulatory Robot. I have the link here, and I can, if you can't access the link, I can actually send it to you as well. Just email me. The Regulatory Robot will walk you through questions regarding your product, and will make recommendations for compliance items to help you to really confirm mandatory product regulations, confirm applicable product standards, confirm applicable labeling requirements, confirm applicable testing and documentation certification requirements, and confirm any facility requirements. The tough part in researching product compliance is that the US government agencies operate their own websites. They're all separate. So there's no really official one-stop shop for product regulatory information in the US. It makes it kind of challenging. A quick note for children's product compliance: if you sell children's products, there are a ton of special requirements when marketing and selling children's. Here are a few. So all children's products must include permanent tracking information on the product and its packaging. All accessible component parts of the children's product must be tested to demonstrate compliance with lead content. There are no mandatory federal requirements, especially for jewelry. However, there are voluntary standards for children's and adult jewelry that represent industry best practices. There's a legal obligation under Section 15 of the Consumer Product Safety Act to report to the Commission when you receive information about your product that may reasonably support the conclusion that a product fails to comply with any requirement, contains a defect that can be hazardous, or creates any unreasonable risk of death. Manufacturers and importers of children's product must certify compliance with applicable CPC requirements. So those are just kind of a few of the elements. There's also elements required in the CPC, which are identification of the product covered by this certificate, citation to each CPCS children's product safety rule, identification of the importer or domestic manufacturer certifying compliance of the product, contact information for the individual maintaining records of the test results, date and place where this product was manufactured. You provide the dates and the place where the product was tested for compliance, and then identify any third-party CPSC accepted laboratory on who's testing the certificate depends. Well, that was a lot. So now you know what the four of the most important legal protections are for your e-commerce business. In the next video, I'll cover the how to actually put these legal protections in place throughout the entire life cycle of your business. Leave a comment down below if you're watching live or in the Facebook group, or any questions you might have or aha moments. Send me an email, anything that you might have. Thanks for spending your time with me. I know it's valuable. I'll see you in the next training.